Now to Minneapolis, where closing arguments began in the federal trial for 3 former officers charged in connection with George Floyd's murder. Thomas Lane, J. Alexander, Kueng and Tou Thao are accused of failing to provide medical aid to Floyd, while Derek Chauvin pressed his knee against his neck for more than 9 minutes. Kueng and Thao are also charged with failing to intervene. Jurors heard more than 6 hours of closing arguments today before court was adjourned for the day. Deliberations will begin tomorrow. My panel of experts still with me: civil rights attorney Adante Pointer and criminal defense attorney Drew Benbow. All right, guys, let's start with the prosecution's closing, where they began by emphasizing the 3 ex-cops as one single group, talking about George Floyd being in their custody and in their care. Lead prosecutor Amanda Sertich then began breaking down the cases against the 3 defendants individually, showing how each had failed to act as Chauvin knelt on Floyd's neck for more than 9 minutes, ultimately killing him. Drew, how would you grade the prosecution's closing arguments?
You know, I would grade the prosecution's closing arguments as a solid B+. Okay, so lumping them all together, absolutely. One problem is that Thomas Lane should have been charged with 2 charges also. He was only charged with 1. And the other 2 got the other 2 charges of failure to intervene and failure to provide medical attention. Now, Lane claimed that he couldn't see any faces. He claimed that he did all he could, and obviously it wasn't enough. He knew it was right. There was evidence to show that he knew what was right. He just didn't have the intestinal fortitude to do what's right. And that's what the prosecution talked about. And I think that was a solid point.
Adante, your thoughts on the government's final arguments?
Well, I thought it was pretty persuasive. You know, they point to the fact of the inaction, but more importantly, I think they educated the jury throughout the trial, and then they reemphasized the idea that, as opposed to what some people might think, that officers don't know what to do, or they're overwhelmed by a moment, or they don't know how to walk and chew bubble gum, make sure that the officers aren't being attacked, if you will, but also know how to bring somebody into custody without killing them. These are situations that officers train for. These are situations that officers are taught how to handle. And so those are the type of excuses that really hold no weight and no water. I thought the district attorney, the prosecutor, did a good job with essentially educating the jury, reminding the jury that these officers knew very well what should be done and how to do it. They failed to do it, and they willfully failed to do it. And they took a see no evil, hear no evil, do no evil approach, while great evil was taking place against George Floyd.
Well, towards the end, the prosecution did emphasize that they don't need to prove to the jury that the 3 officers acted with ill will or intended to hurt George Floyd, only that they acted with deliberate indifference. Drew, we all know that it's difficult to prove what is in the mind of these officers on the day in question, but here prosecutors just have to show that there was an indifference. You claim that Lane should have been charged with 2 charges, just like his co-defendants, because of that indifference. I tend to disagree, but I want to get your thoughts. Did the prosecution actually prove that indifference?
Well, I think the prosecution proved the indifference with respect to the other 2, not Lane, because of course that's not what he was charged with. But Lane again said he could not see the face until Mr. Floyd was lifted into the ambulance. Now, I watched the video, and then I turned the video off and listened to the audio. Now, Lane was sitting at the feet of Mr. Floyd, so that's why he says that he could not see the evidence. But what I heard was George Floyd's pleas and his life leaving his body, right? It made me sick. What I heard were the pleas of the bystanders, right? I heard the pleas of the bystanders telling him exactly what to do. Turn him over, right? Give him CPR. They told them what to do. It's not like they didn't, it's not like, you know, he didn't know what to do. They told him what to do. He was trained. The evidence showed that he was trained. By the way, he wasn't just a rookie, right? He was a trained, fully fledged police officer. By the way, he was also a correctional officer in a past life. So I outright reject the claims that he was just some novice and didn't know what to do.
Right, and that indifference was shown by them willfully ignoring George Floyd's pleas that he couldn't breathe, a number of 25 times to be exact. All right, so let's talk about the defense's closing arguments. First up for the defense team was Paul, the attorney for Tou Thao. During his closing arguments, excited delirium once again came up. He told jurors that during the struggle, Thao thought Floyd was exhibiting superhuman strength. We've heard this argument before, and it clearly didn't work during Chauvin's state trial. Adante, why would Paul focus on what Floyd may have been like before he was in handcuffs, on the ground, not resisting? That's what matters here, right?
It does. That is what matters. But we see this tried and true defense, this ruse, if you will, trotted out time and time again in order to explain away bad behavior, criminal conduct, and the death of victims of the police. Excited delirium is junk science. It's been debunked more times than there are stars in the sky. You know, this is some type of phenomenon, health phenomenon that they claim is real, that only seems to happen when the police are involved. And so, you know, to me, when I heard the defense argument, you know, it was a yawner, if you will. But I also understand that if you want to believe and excuse away the conduct of the police, it's an easy excuse. Why? Because you portray Mr. Floyd as being this wild animal of a man, a beast, if you will, that has to be subdued, that can act in any moment to overpower these police officers, and they had to subdue him and treat him in this way, or else he'd be on the loose and a danger to not only them but also the public. That's just treading on stereotypes and caricatures of black men and black people that white supremacists have been using since we touched the shores of America.
Listen, I've got 90 seconds left, but I want to get one more closing argument in, and that was by Tom Plunkett for J. Alexander King, who stressed in his closing that his client didn't act willfully in the crimes that he's charged with. He went on to say that King's inadequate training, his lack of experience, and his perceived subordinate role to Chauvin all cast doubt on the prosecution's case. According to reporters inside the courtroom, though, Plunkett ended his closing arguments fired up, yelling and asking the jury not to fall to mob rule. Drew, is this an effective strategy on the part of the defense? It's never a good idea to yell at a jury, but to tell them not to fall for mob rule. Strategy, will it work?
First of all, nobody likes to be yelled at. Nobody likes to be told what to do. And so I don't think it'll work. I think his emotions got doesn't seem like this is a strategy. I think his emotions got the best of them. And I don't think it's going to work.
All right, guys. Well, we're definitely in verdict watch on this trial, so we're definitely going to keep our eyes peeled on this case. Attorneys Adante Pointer and Drew Benbow, thank you both for your time and expertise, and I appreciate it.